It has been suggested that we have the best legal system in the world if you can access it. We'll talk about access to justice right now on The Law Works.
From West Virginia Public Broadcasting.
Closed captioning for The Law Works is made possible by a grant from the Monongalia County Bar Association to support legal information and education for all West Virginians. The Law Works is made possible by a major grant from the West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and legal system, promoting public knowledge of the law in West Virginia. By the generous support of Software Systems Incorporated, a West Virginia company established in 1975, providing high-end support services, programming, and consulting for county government AS400 mid-range computer systems, as well as PC-based systems. And by viewers like you.
If you have a legal problem, you can go to court, right? Well, there may be some problems with that. My guests are Justice Brent D. Benjamin of the West Virginia Supreme Court of Appeals and Deborah M. Bogan, Director, West Virginia Access to Justice Commission. Deborah, Justice Benjamin, thank you for joining us.
Thank you, Dan.
Thank you.
So, Justice Benjamin, why are you concerned about access to judgment? The courthouse doors are open.
The courthouse doors are open, but whether people can effectively use the system that they pay for is another matter. And as a judge, it became apparent to me, the longer I became a judge, that people were having problems navigating their way through the West Virginia civil justice system. In many cases, it was because they were having a hard time finding a lawyer. And if they found the lawyer, they had trouble paying for the lawyer. That's become even harder for a lot of West Virginians as the economy's gotten worse.
Isn't that true, though, of every justice system in the history of our civilization?
Well, it may be, but that doesn't mean it's right, and it doesn't mean we can't do better. And I think as a judge, part of my role is to make the system that the people pay for, that they expect they can use, something that they can actually use. And so our goal has to be always try to make it better.
So you sponsored or proposed an initiative to the state Supreme Court.
In 2009, when I was Chief Justice, we have a rotating Chief Justiceship, so each year one of us alternates. That was one of the programs that I felt was important for us to go forward on. Now, this was not something that started in West Virginia. Access to justice programs have occurred in other states, so it was something that I could look at and see was working in other states and bring here. Talked with the other justices. Of course, we had two new justices, Justice Workman and Justice Ketchum, that joined the court in 2009. They were very supportive of the notion, as was Justice Davis, and then of course Justice McHugh came on. And between the five of us, we felt there was a need that needed to be addressed. So we put together a commission. The commission was charged with, first of all, looking at what the needs are for West Virginians when they're accessing their civil justice system, not just in the substantive law, but also physically, how to access and navigate the courthouse. Because we've got a lot of people who have handicaps, impediments, and so on that also need help looking at it. So we first tasked the commission with looking at what are the needs, and then from there we will assess how can we fix those needs. And
when you talk about access physically to the courthouse, a lot of courthouses in West Virginia, you had to go up the stairs, and if you had trouble with the stairs, that was a problem. There were no elevators. If you needed help getting up to the third floor or whatever, you couldn't do it.
That's right, and they're very historical and they're very beautiful. But if you have hip trouble, or if you have a problem with your knees, or if you're partially blind, or you're elderly, it can be a nightmare trying to navigate through that system, much less try to pursue a legal remedy or defend yourself against some type of an action.
So we talk about access to the courts or access to justice. We're talking about access across the broad spectrum.
That's exactly right.
So, Deborah, you are the director of the Access to Justice Commission. What does your commission do, or what are you doing?
Well, as Justice Benjamin said, we've been charged with identifying what the needs are across the state. So we started having forums in August this year. We are actually in Morgantown November 1st to have our 5th forum. We've been in Beckley, Huntington, Martinsburg, Wheeling, we're in Morgantown, and then we'll be in Charleston. And the purpose of those forums is we've invited the citizens of the state to come out and address the commission. We have invited stakeholder agencies who provide services to the people who need access to the system in many different ways to come out and speak to the commission and tell the commission what the barriers are that they have faced, whether it has been getting an attorney or whether it is finding out where the courthouse is, or a broad spectrum of problems that people have had. And in the meetings that we've had, there's been not really a repetitive theme. We've had different people show up with different thoughts and ideas and different problems. So that's been a good thing because it's given us a wide range of issues
So
that
you're
are
not
going to
hearing
need
the
to
same
be.
thing over and over again?
No, typically we're not. There are some things that are repetitive, but in each region that we have attended, there have been different issues. For example, when we were in Huntington, the Associate Dean for Students talked about housing issues and landlord issues that foreign students were experiencing. And
That would be the Dean for Students at Marshall.
Yes,
Right.
yes. And
Well, what does housing for students at a state university have to do with access to justice?
Well, if a student is being thrown out by a landlord for no reason, without their deposit that they put forward, or the deposit is being held for no good reason, in many cases we have students who live outside the state. They're left with very little remedy. They don't know what to do. They don't know where to go. WVU actually has, I believe, a lawyer that they can talk to at least. But students have rights too, and if somebody's taking advantage of them, then they need access to the civil justice system. And that's what the dean was talking about in that regard.
How do you balance this, though, with the concept of we're each responsible for what we do for our own role in society? If you have a legal problem, it's up to you to go find help.
Well, I think that's right. Once you're on the field, it's your obligation to play the game, play ball. But getting onto the fields where a lot of people are having trouble, just getting there. And our job as a court system, our job as judges is to make certain that the opportunity to litigate is fair and free and equal for everyone, that everyone has a meaningful access. Now, if their case is not a good case, they're going to lose, well, that's fine. But at least they had that opportunity. And that's a right, and they pay for that right through their taxes. They pay for the civil justice system. They should be able to use it. And the purpose of the civil justice system, in some cases, is to be able to resolve in a meaningful manner and an efficient manner disputes between citizens. If they can't even get on the field to do that, then it's not serving them.
Well, you said fair and free. Are you suggesting that they shouldn't have to hire a lawyer or employ a lawyer?
Well, in many cases, trying to hire a lawyer is just not in the equation. We see right now in some areas of the state up to 70% of the people going through divorce without lawyers. It's not that they don't want lawyers. It's that in some cases they're having trouble finding folks who do divorce work because there is a small subset of lawyers who do that. Now there's others who do it as part of their practice. But increasingly, they can't afford the lawyers. In many cases, a lawyer will need a $10,000 retainer because it's going to be a long case. Well, if the person had $10,000, they may not be, that may be part of the reason why they're getting the divorce. And so what's happening is increasingly, and then this is made even worse when disposable income is down to almost nothing as the economy gets worse. If you need a lawyer, how are you going to afford it? If you can't afford it, then you have to represent yourself. And that's a scary proposition. Part of access to justice is to try to make the system a little bit more user-friendly.
We probably ought to point out that not all divorces cost $10,000. It is possible to get divorced for less than that, but it is or can be an expensive undertaking.
And it can be a very scary undertaking.
Well, and I have to counsel clients frequently because one of the first questions that a prospective client will ask you is, how much is this going to cost? And in a divorce case, you have to be aware that the cost of the case start to finish is in large part controlled by what the other party does or doesn't do, and you have to bear in mind that the other party probably doesn't much like you right now, so if they can see a way to make you uncomfortable either by spending money or just otherwise uncomfortable, they may well do that.
Well, now there's a lot of people who think legal aid's out there to help them, but legal aid is a program that's there to help certain income levels, and there's many West Virginians who come in right above that income level, so they don't have access to legal aid. And in many cases, if legal aid's being used by one spouse, well, then it's not available to the other spouse. More importantly, and I think this will come as a shock to a lot of citizens, but it's even a bigger shock to a lot of the lawyers in the state, is we have 55 counties. We only have 52 legal aid attorneys in the entire state. And they work very hard. They work long hours, and they do one heck of a good job. But there's only a finite number of them. So there isn't this core of public lawyers out there just waiting to help people. That's just not there.
We're talking about the public's access to justice. My guests are Justice Brent D. Benjamin of the West Virginia Supreme Court and Deborah M. Bogan, Director of the West Virginia Access to Justice Commission. I'm Dan Ringer, and this is The Law Works. We have many times talked on this program about legal aid and the work that they do, and you're right, they are outmanned population-wise. The ratio is just horrible. They do a terrific job. They do have a program where they use private practice attorneys who volunteer their time to help some folks, but still in all, legal aid is available only to folks who are truly indigent, who just maybe have enough money for food, possibly sometimes, but not for all the basic necessities.
No, and what we're seeing, and I'm sure for not just your listeners, but for pretty much everybody. We know West Virginians who, whether it's the elderly who are on fixed incomes or the young couple that are just struggling each week to make ends meet on minimum wage jobs while they're building their family up, or the folks that have just gotten out of school who are paying off student loans and trying to make a go of it. The thought of disposable income just isn't there. Everything else is grabbing that money first. And the last thing on their mind is trying to find an attorney. Now, one of the things that things that we're trying to do is figure out what are some of the alternatives. And as you said, in the divorce proceeding, a case may cost $1,000, $5,000, $10,000. You never know when you get into it how much it's going to cost, because you've got to be in it from beginning to end. Well, some states allow their lawyers to come in not for the whole case, like we have in West Virginia, which has good historical reasons, but allow what's called unbundling, where a lawyer can come in simply for an issue. So if you have a couple that are in agreement pretty much on divorcing, except for maybe one or two issues, such as alimony or visitation or something like that, perhaps it makes sense that we consider changing the rules to allow a lawyer to represent just in that area, because one, it's a finite area, and it would be a lot cheaper for the individual, and maybe if they couldn't afford a lawyer in the whole case, they could afford a lawyer in that one issue.
It's an attractive proposition.
So it's a thought.
Yeah. As a private practice attorney, though, I can tell you that when you start to help someone, there is a tendency to want to be able to continue to help them. And sometimes to be able to do that, you have to be able to say, look, I'm in it for the duration, or I'm not in it at all. And because you need more help than you know. You may think you just want to talk about child visitation, but what you really want to talk about is parenting and how to relate for the next 18 years or something less than that.
That's absolutely right. So that's one of so as we approach this, we're looking at options that are out there like unbundling. But before we would go forward with that, we would have to listen to all sides of it, because there are very legitimate reasons why we don't have unbundling right now in West Virginia.
What other kinds of problems are you becoming aware of through these meetings?
For example, we had a domestic violence victim talk at one of our meetings about the need for separate waiting areas in courthouses prior to a hearing for a domestic violence victim and the accused. That's being taken care of around the state, but there are still courthouses in which there's a common waiting area. And as you can imagine, it can be quite a volatile situation.
And that was a problem that simply wasn't recognized until relatively recently.
Exactly. Another issue that she raised was escorting the victim to the parking lot by a security officer after the hearing, because again, as you can imagine, after a hearing it can be quite a volatile situation, and a lot of attacks take place after the hearing. So that was an issue that was raised at one of our forums. We also had a young lady, actually we had a sign language interpreter who showed up to do sign language interpretation for us at one of our hearings and asked to address the forum, and talked about her young daughter who was pulled over at night. She had a cochlear implant. And
that's a hearing device.
Exactly. And she spoke well, but with a slight impediment, such that the officer thought that perhaps she had been drinking. And there was an exchange that took place there, and the girl was frightened, as you can imagine, because it was difficult for her to communicate. The officer wasn't understanding. And in that particular situation, we're talking about education, whether it be the officer or different mechanisms. It's not always just about getting an attorney, but lots of different information that can be disseminated, whether it's how do I get to the courthouse? Where's parking at the courthouse? Where do I go once I get there? All of these things are intimidating to people who aren't involved in the legal system. It's easy for you or me who are familiar with the courthouse and what we need to do when we get there. But for somebody who's not familiar with that, and this is a foreign language for them, it's a very difficult proposition for them. So we start with education, whether I said as it be the officer or, how do you get, where are the forms that we need to fill out and complete. There are court-approved forms that are available to the public that can be used in order to access the system.
We're talking about the public's access to justice. My guests are Justice Brent D. Benjamin of the West Virginia Supreme Court of Appeals and Deborah M. Bogan, Director of the West Virginia Access to Justice Commission. I'm Dan Ringer, and this is The Law Works. Lawyers have trouble communicating with each other. I cannot imagine a layperson coming into court and listening to a lawyer, perhaps on the other side when he or she doesn't have one on their side, arguing to the court and then being expected to make some response to that, or in some cases listening to the judge explain in judge talk what they're supposed to do or how they're supposed to do it. I'll give you an example of that. I'm involved in a case where the United States government is on the other side. The Assistant United States Attorney is in fact a friend of mine, and we have been trying to communicate about this particular case, and there was one issue where I said I would like to see or examine this. She heard something completely different. And then she responded trying to put limits on it, and I heard something completely different. And it was a couple of weeks before we realized that we weren't really talking about the same thing. And when we did, it was kind of like getting hit with a pie in the face. We realized there was no disagreement here. There was no problem here. We just weren't talking the same language, or if we were, we weren't hearing it.
And therein is, for the lay person trying to understand not just the substantive law, but the language that goes with it, it is a nightmare. And one of the areas that we have already actually started moving forward on already, because it was such an apparent need area, was the area of workers' compensation. Now that's not something traditionally that's in the courthouse as opposed to an administrative agency, but increasingly what we were seeing was that it's a very complex area. Lawyers themselves admit that they don't understand it all because it's so complex, but because there's no ability to recover a contingent fee, which of course is a percentage of the recovery, for things like getting medical benefits for someone, the person was left without an attorney. And in many cases, they were going up against insurance companies or big employers who did have attorneys. And at some point, you just say, hey, well, wait a minute, there's a fundamental fairness issue here. The person should at least be able to understand what's happening here, how to go about getting their benefits. And I mean, it was something as simple as, imagine how frustrating it would be if you were told, well, if you knew that you had a problem, so you said, okay, I want this recognized as an injury. And the response was, well, no, we're not going to recognize it, you don't have enough medical. And your response was, well, that's what I was asking for. I'm asking for a referral to assess whether I've got this. Well, no, we're not going to give you the referral because you don't have that condition. And so trying to navigate through a system, it was like Alice in Wonderland.
You have your own catch-22.
Where up is down and down is up, and it's very frustrating, and it's frustrating for lawyers. So you can only imagine how difficult it would be for the person who's actually injured and needs the help. So that's an area where we've already started forward, and I'm happy to say that lawyers in the state, both claimant lawyers and employer lawyers, are actually working together now to try to identify some of the biggest problems and make recommendations. Because workers' compensation is a statutory system, then what we'll do as a commission is take recommendations to the legislature so that hopefully the legislature can act.
But those kinds of problems exist in every aspect of the law and at every level of every aspect. Let me give you another example. This is one of my pet peeves. On each lawsuit that is filed, the circuit clerk's office staples a document called a summons. And that summons says, almost literally, you are required to make answer to, and there is a name, it's usually the other side's lawyer, within 30 days. What's an answer? And I have seen over the years, the other person, the person being sued, will pick up the phone and will call the lawyer whose name is there and will say, I don't like this, I don't know what this is about. That's an answer. But many lawyers don't recognize it as an answer. Or their receptionist or assistant will take that phone call and not recognize it as an answer. What in fact should happen after something like that takes place is the lawyer should file a brief document with the court saying, John Doe called me and made answer, said he didn't like it, and he denies that he did anything wrong. That's an answer. West Virginia is what is called a notice pleading state. Anything you do is supposed to be good enough to join the issue, and any form of denial is supposed to be good enough to be a denial. But if the person who got the paper doesn't recognize that they've got to affirmatively come forward and submit a writing to the court, or are supposed to, they won't do it, and they may very well have judgment taken against them. So, Justice Benjamin, Ms. Bogan, let me ask you to do this. Change that form and put the words across the face of it. You are being sued. You may want to talk to a lawyer.
Well,
Okay. Well, and not to be flippant, but it reminds me of the old adage: only lawyers could take something 40 pages long and call it a brief.
That's right.
So you know, I think the point is very well taken. That sometimes in the practice of law, the lawyers get used to a certain meaning, and from a semantic standpoint, they understand things to mean something, but to the everyday person out there, it doesn't mean necessarily that. And I think you've got a very good point there.
The language of law.
But that's the kind of thing that we need people to come out to our forums and explain to us.
Well, talking about putting documents in plain language and taking that language and simplifying it so the average person can understand
Well,
it.
as much as you can, because it is absolutely true that the history of law has turned on very precise meanings of words, and we have developed a language to describe things and to say things as precisely as possible. The problem is civilians, or lay people, don't speak that language, and so we can, quote, dumb it down as much as we can, but it's still going to be difficult to read.
Well, and the goal is that that legal issues get decided on the merits, not on some gotcha procedural error. So again, it goes back to from a procedural standpoint, trying to make certain that we level the playing field as much as we can, recognizing we're never going to make it perfect, but but everything starts with the first step. We can make it better, and that's what we have to start focusing on.
You can only strive to improve.
That's right.
But you may not succeed in everything.
And I
think
think the public understands that part of their court system is to make it better, and that's what we're striving to do.
Justice Brent Benjamin, Deborah Bogan, thank you very much for being with us.
We appreciate the time.
Thank you.
Thank you also for being with us. On behalf of the Law Works, I'm Dan Ringer. Good evening. On the Law Works website at thelawworks.org, you'll find a listing of recent The Law Works programs, additional information about this show's topic, and video of this and recent shows. You can also find the Law Works programs on YouTube and iTunes. If you would like to suggest a topic for a future The Law Works show, or if you're a school teacher and would like to receive a DVD of this show for classroom use, send us email at thelawworks@comcast.net or visit us on Facebook.
The Law Works is produced in cooperation with the West Virginia Bar Foundation, the Mountain State Bar, the Monongalia County Bar Association, and the West Virginia University College of Law. The Law Works is made possible by a major grant from the West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and legal system, promoting public knowledge of the law in West Virginia. By the generous support of Software Systems Incorporated, a West Virginia company established in 1975, providing high-end support services, programming, and consulting for county government AS400 mid-range computer systems, as well as PC-based systems. And by viewers like you.
From West Virginia Public Broadcasting.